Number 7, Brookdale Physicians versus Department of Finance. Counsel.
Good afternoon, Your Honors.
Good afternoon.
If I may, I'd like to reserve 1 minute for rebuttal.
You have a minute.
Thank you, Your Honor. May it please the Court, Andrea Chan for Appellant, New York City Department of Finance. Your Honors, the case before you presents a very important question in the realm of tax exemption law, specifically under Real Property Tax Law 420A.
Ms. Chan, is it 420A sub 1 or 420A sub 2 or both that we're talking about here?
We're talking about both, Your Honor, and the petitioner does not qualify for either. I would say specifically, if you had to let me choose one, I would say A2. But under A1,
Could we talk about A2 for a second?
Yes.
Because when I look at the 2017 letter denying the exemption, it speaks of leasing beyond the operating costs of the property, which that led me to think that it was A2. But
Yeah.
upon further examination, I'm not sure A2 applies here. So can you tell me why A2 would even apply to this situation where a not-for-profit is leasing to a for-profit?
It actually does specifically apply to A2, Your Honor, because under RPTL 420A2, when a property is leased or otherwise used for a purpose that's not exempt, it is automatically subject to taxation. That's what puts petitioner directly under A2.
Doesn't that go against all of our precedent?
How so, Your Honor?
Well, to jump in, I'll give one example. We have a case from 1980, Sisters of St. Joseph, which seems to say A2 only applies where one not-for-profit is leasing to another not-for-profit, ostensibly for a different use. Here, we have a not-for-profit leasing to a for-profit, so that leads me to the conclusion that if something's going to apply, it would only be A1.
Your Honor, under the plain language of the statute, when a property is leased or otherwise used for a non-exempt purpose, then it's subject to taxation. What Your Honor is referring to is the subcategories underneath. If the not-for-profit is leasing to another not-for-profit, then we implicate Sisters of St. Joseph.
And A2. I mean,
And A2.
Our language from Sisters of St. Joseph is A2, subdivision 2,
Yes.
is specifically applicable where one tax-exempt organization leases its property to another. That's the language. And to me, when I read that, I say, this isn't that case. This is a different case.
What Sisters of St. Joseph is referring to, Your Honors, is when a not-for-profit is leasing to another not-for-profit, then what we need to look to is whether or not the income exceeds the carrying maintenance and depreciation costs. But if you look further up in the statute, Your Honor, first, you're correct. You look at RPTL 420A1. Is it owned by a not-for-profit? Is it used exclusively for that not-for-profit's purpose? In this case, it isn't. And then when you look at A2, because what's happening here is the Schulman Fund is leasing to a for-profit. This is a not-for-profit exemption. The Schulman Fund is supposed to be using the property specifically for its charitable purpose.
So could we go to A1? Because under
Yes.
A1, you could lease it, and there's a reading, I think, at least a reasonable, colorable reading of it, that you can lease it at a market rate, at a profit, as long as you satisfy all the other conditions that are attached in A1. It can't be used for the benefit of one of the officers or directors, and it has to be used for a listed purpose. There's requirements, but leasing it at a profit doesn't seem to be one of the requirements in A1.
Respectfully, Your Honor, it actually is. Because if you look at, for instance, this court's precedent in matter of Lackawanna, the local development corporation was leasing to a for-profit manufacturing company, arguing that somehow by leasing to a for-profit corporation, that furthered its charitable purpose of spurring economic development. This court very wisely held that no, a not-for-profit cannot lease to a for-profit business under a not-for-profit exemption.
But what if the for-profit business is engaging in a permitted purpose, i.e. a hospital purpose? Because this was a dialysis center which my understanding is Brookdale Hospital doesn't have a dialysis unit in the hospital, is it a plausible reading to say, well, they're engaged in hospital activity, so that is one of the permitted uses even for a for-profit company?
It's not, Your Honor, and for two reasons. First, we must be clear, the petitioner has blurred the lines of who the parties are in this litigation. The Schulman Fund is the owner of the property. The Schulman's Fund purpose is what we're looking at. Brookdale Hospital and the Nursing Institute are not owners of this property. They're not even parties to this litigation. We shouldn't be looking at a hospital purpose. We should be asking, does the for-profit dialysis center, does that further the Schulman Fund's purpose of managing assets and charitable fundraising? It does not. The Schulman Fund is a landlord that is renting its property to a commercial business. If we think for a moment expanding this.
Counsel, was that the basis for the determination before you got into court? I'm having a little trouble understanding, what are we reviewing here? What are the courts looking at? Are they looking at your agency determination, which as far as I can tell is on page 55 of the record in an email, or are we looking at everything else you put in after the fact?
In this court's precedent in Greater Jamaica, Your Honor, the court looked at not just the agency determination, but the affirmation of the Corporation Council and all of
Really,
the...
what they looked at there were almost admissions. They looked at the petition and what the response to the petition was, because they took that, to me it seems, like admissions in the case. So they said, well, the petitioners came in, who are the taxpayers, and they made what seemed to be these representations in their petition, and you can use those to elucidate your agency determination. But there was an extensive agency determination letter in that case, which is really, standing alone, the court said was enough. Here I see an email which doesn't go into any of the things you're now claiming as the basis for the determination, and it seems to me quite different, and also quite different from an initial determination. To let an agency send out this email, the other side has to bring an action, and then you can come up with the additional reasons why you're taking the exemption away.
This is not the first time that this property has been litigated, though, Your Honor,
But
respectfully.
you lost, right?
Yes, Your Honor, but the 2017 determination, it reflects back to the 2014 decision, and even the lower court, Justice Chan, in her 2018 decision, references the prior court's decision
So,
and
okay,
incorporate...
how does that affect what's in front of the agency at the time you made this determination, not what's in your papers in this proceeding?
Yes, Your Honor. What was in front of the agency at the time was the known fact that this was a for-profit dialysis center. And it knows that because when you look at Mr. Oberman's email, he says, looking back at the court's prior decision...
That's not what you said in your email, though, as the basis for your revocation.
I understand, Your Honor. What the Department of Finance did was it looked at the 2014 decision of the lower court and said, assuming that this now needs to be treated as a not-for-profit, which it isn't, then we will then look at whether or not the income exceeds the
And
So
that's your basis, then? That's the basis for your decision, is that fact?
It's not the full basis, Your Honor, because on this record, if you look at the uncontested facts in this case, undisputed by petitioner, the petitioner does not qualify, even under the plain language of the statute. And, Your Honor, the appellate division decision made very serious, significant errors in its decision. It did not conduct a proper analysis under 420A. It conflicts with this court's precedent in Lackawanna by not looking at the actual and physical use of the property. It conflicts with Genesee Hospital by allowing the commercial practice of medicine to take place on a tax-exempt property. And it flies directly in the face of Stuyvesant Square Thrift Shop and Greater Jamaica by holding that just because the Schulman Fund places its profits back into the charity, that somehow profits should be excusable.
Thank you, Ms. Chan.
Thank you, Your Honors.
Good afternoon, Your Honors. Menachem Kastner, Cozen O'Connor, representing the Brookdale Dialysis. Clearly, if you look at the determinations Judge Garcia pointed out, they take that determination and he reference at the end, we made a mistake, we blurred. We say we feel the court below was a non-exempt to a non-exempt Mea culpa, I made a mistake. But in any event, we want to see the profits that were realized. When you're using the word profits that were realized, you're under A2 automatically. That's where you fall into. Profits realized as part of A2, not part of A1. A1 speaks about whether any employee, officer, director has gotten a pecuniary.
What about this argument, which seems to be something like there's law of the case here and findings that could inform their decision here, although not mentioned in this email, the prior litigation?
I didn't follow the question, I apologize.
So it seems to be an argument that this email is also informed by prior determinations in unsuccessful litigation by the city in this.
I don't
with
see the
respect to
nexus,
this
Your Honor, respectfully. They lost the first proceeding. They brought 3 times revocation. One they backtracked on. The judge in the first proceeding actually laid out the breadcrumbs on what they should follow. Said, you didn't look into the use, look into the use. No one looked into the use. That is fundamental. Adult homes by this court found that it's use and it's not profits that count. They then sent us another letter revoking, and then after I wrote a letter to them, they undid the revocation and then came back with a 3rd attempt on it. What they're missing is the burden of proof is not on me to show what my client is, who's running what. The burden of proof, because this is a revocation case, is upon them. They abysmally failed to meet their revocation requirements.
So does this go beyond burden of proof? Are you saying alternatively or additionally that they failed to even allege the right basis for
Yeah,
revocation?
Correct, Your Honor. If I may, at the appellate division, in their brief, they say, rather than failing to undertake such an examination of the use, the City Department of Finance embraced the 2014 decision, believing it to have determined that the leased premises were occupied and used for purposes that qualified the building for exemption under 421A. They concede, they gave in, they accepted that the use was proper. Once you accept that use is proper, you're automatically under 421A1. You don't get to 421A2. We met the mandatory exemption requirements under the case law. Lackawanna was a totally different case that they bring up. There, the entity was no longer doing the purpose that it was. It wasn't a charitable entity, and it was subleased to a manufacturing plant. When they say we blurred the line of who Schulman is and what they do, this was never raised. It's not part of page 55 of the record. What seems to be happening here is they do their homework after the exam. They make
You
a
don't get to
point-
make that argument now? Is that what
Say-
you're saying? What is the purpose of Schulman? Are they engaging in a hospital
well,
activity?
if
What are they doing?
If they had done what they were supposed to do, Schulman's certificate of incorporation is a public document. Specifically says it is to administer health to the community, and it goes into depth. It's not just as in Stuyvesant Thrift Shop, where it was a entity that just handed out money to these eight other corporations. They are integral in doing the work. However, even more so.
I'm sorry, is Schulman in the business of
Is
delivering,
Schulman-
excuse me, is Schulman in the business, not for profit, of course, of delivering medical services?
Schulman is in charge of making sure the hospital services are done properly and that both...
What does that mean? Because I am confused. I thought that Schulman basically worked on the fundraising. Be careful what you admit to here, because it is a not-for-profit, and it's tax,
No.
you're claiming this tax is excluded from taxation, both federal and state.
Respectfully, Your Honor, under the Sirogi case by the Court of Appeals...
No, I'm asking you, what is the purpose of
I have this-
Schulman? It is organized to do what? I thought it was to
Organized-
fundraise and to be the money manager.
It is organized to fundraise, oversee the operations of both the Institute as well as the hospital. It is involved heavily in, organizing what's going on with these two other aspects, and it's all under one umbrella from the Brookdale Center. It's one parent
So
corporation.
it does more than fundraise and money manage. Just to be clear, she may she may argue there's more to their argument, but I understood them to be saying that's Schulman's mandate, that's their purpose.
They are not, they are in charge of overseeing the work of the other two not-for-profit organizations. There is one entity overseeing what they do. It is involved in the daily operations of the hospital.
You mean they make decisions regarding the provision of medical services, or do
No.
they read the budget?
The latter, Your Honor.
Okay.
The latter, Your Honor.
So they're focused on the financial health, for the other two entities.
Correct, is my understanding.
All right.
And under the Sorogi case by this court, the fact that they oversee it, that was exactly the same type of case where there was an entity, properties that owned the property, hospital was running it, the court there held, it was the alter ego type of case in that situation, that is totally proper and it falls within the exemption. What's happening here is the knee-jerk reaction every time to whatever someone brings up in the court, and they come up, like the Schulman one, was never argued before.
So let me ask-
Sorogi, it's proper, it wasn't argued, et cetera.
Let me ask you this. Could you maintain the tax exempt status and rent to an auto repair shop?
Can you maintain the, well, depends what the exempt, if, the answer would be no. If it was an exempt, if the entity was an exempt ownership, was an exempt one, and put in an auto shop that had nothing to do at all with the exempt purpose of the corporation that owned it or that was conducting, because you have the word conducting statute, I would say, standing here right now, that would not meet the exemption.
And what if it was a for-profit business auto shop that repaired only hospital vehicles and vehicles owned by hospital employees?
In that situation, depending if it met the qualifications like we have in this case, I would say yes, it would be exempt. If it was an auto shop that the people working the auto shop were employees of the hospital, were paid by the hospital, and
No,
it
it's a
was
separate corporation.
ambulances.
Yeah, separate corporation that's a for-profit corporation. They're not employees of the hospital.
If it was I would say if it was an auto shop having nothing to do with the purpose of the hospital, I would say it should not be in that situation. However,
What if 80% of the vehicles repaired were affiliated with the hospital and 20% were not, were just me?
I would say in that situation that it would meet the purpose because exclusively, as we all know, in the statute means primarily, and in the Watchtower case, the adult homes case, and various other cases from this court, found that 90%, the 10% does not override the exemption and bring it out. So I would argue in that case, if 80%, as in our situation, the 80% number, it would be exempt. It would be properly exempt in that situation. Because it's exclusive means primarily, not totally.
What if the hospital had a dialysis center, but not as expansive as the one the company leased to here? Would that matter?
If the hospital had its own dialysis center,
Correct, but just couldn't handle perhaps all of the potential patients that would want to use that. There's a spillover, some are referred across the street. What about
If-
that case?
sorry, if it was the same amount you had, they were servicing Ulster Hospital, they were using their own machines at the hospital, they were going into the hospital with their
Yes.
own machines because there was need for that, I would say in that situation it would be exempt.
So why isn't that competition? Why isn't that subsidizing a for-profit? Why isn't, I'm a little confused why you say yes to that. I understand your answers in response to Judge Wilson, but this one confuses me.
If the hospital had its own dialysis center, but there was extra need for more machines and more help, and the people who were working in the separate entity were also employees of the hospital, and we had the same
Not,
staffing.
it's just a private company.
Private
Just leased
company.
across the street to a private company that is not, solely because they are located in that building across the street, pays no taxes. If they were in a different building owned by a private individual, it's not a not-for-profit, they would be paying taxes.
I would say that they could be exempt. I would say they would be exempt.
Again, because it's an important medical service.
Part of the medical services, it's in sync with what the hospital does.
But what
I
if you lease to a pharmacy? And the hospital has its own pharmacy. There's lots of pharmacies, you know.
If
You're
again,
always going to have an overflow, is my point with that one.
if it met the same indicia that we have in this situation, where the employees were staffing employees, they were being paid by the hospital, and down the line, I would say in that case situation that it would be exempt.
Thank you, counsel.
Briefly, Your Honor, I'd like to piggyback off of the hypotheticals that were just posed and implore this court to look at the consequences of this decision and, by extension, what those hypotheticals would mean. If this decision were to be affirmed, the Schulman Fund could purchase property after property and lease to other outpatient medical services, to a physical therapy clinic, to a rehabilitation.
Is that really true, though, Counselor? Aren't we just looking to see if you sustained your burden?
Your Honor, I respectfully disagree, because the consequences of the appellate division decision are very, very severe.
We don't have to
and great.
agree with the appellate division. My question is, and still affirm the finding, the holding, in a way, if we just look at the four corners of your page 55 email, are any of these issues about the brake repair and all of that, is any of that before us? Is any of the ownership and the use, is that anywhere in your email on page 55?
The 2017 email, Your Honor, it relates back to the 2013 determination, which found
Does
that
it reference that in the way you're saying?
it references the lower court's decision in 2014, and Justice Chan's decision also references the decision in 2014. And Your Honors,
And in what way is that reference incorporating your arguments into this document?
Could you repeat the question, Your
In
Honor?
what way is your reference in the email incorporating all of the arguments you've made in front of us into the information you provide to the taxpayer on April 4th, 2017?
Because the 2017 determination, Your Honor, if it hadn't been for the initial revocation, that the Department of Finance determined that the property was being used as a for-profit basis, it wouldn't have looked at it in that manner.
A few things. I don't see a reference to the 2017 decision in this email. I see the numbers about the income,
Right.
and then a line at the end that says, based on this information, the exemption application is denied, based on the fact that the income exceeds the expenses for the property. That's the reason you give in this email.
The language I'm referring to, Your Honors, is when it says from the court's order a few years back. That's what I'm referring to when I say it relates back to the prior litigation. And I do understand the court's concerns, they're valid concerns, Your Honor, but I respectfully ask that it be balanced against the severe mistakes that the appellate division made and the legislature's warning. The legislature warned us about the proliferation of tax exemptions and how much this will erode the municipal tax
Again,
base.
what you say in the actual email is, under the court order from a few years back, that's the language, the for-profit entity was determined to be treated as a not-for-profit organization for purposes of the lease. How does that put them on notice that that's an adverse finding in any way? Especially when at the end of the email you say the reason for our decision is this financial calculation.
I understand, Your Honor. The Department of Finance did misinterpret the lower court's determination. It did. It did. It looked at it, presumed that it should be treated as a not-for-profit, but on the
And you
undisputed
can
facts.
correct that in Article 78 proceeding?
Your Honor, I would have to say, when you balance what is at stake here, what this precedent will set, and what the legislature's mandate to construe
The
tax
precedent
exemptions.
be more careful when you're revoking a 20-year exemption? Why isn't that the precedent we would set?
Well, the initial revocation, Your Honor, in 2013 did specify that. This property has been enjoying a tax exemption since 1996 on the backs of other remaining taxpayers. Whenever a tax exemption is taken off the rolls, it shifts the burden of taxation to the other remaining tax-paying citizens.
Thank you.
Thank you, Your Honors.